Good evening and thank you for staying with us right here in Voice of the People 90.3 FM. My name is Esther Wachuku and here are the top stories. NRC suspends Warri Itakwe train services. In a very recent development, however, President Bola Tinubu, Attorney General of the Federation, Fagbemi Snubs suit seeking to sack a River Sole administrator. Also, Godswill Akpabio petitions police over assassination plot, wants Natasha Akpoti prosecuted. Court dismisses Nnamdi Kanu's 50 billion naira suit against federal government. In a very recent development, 12 IPOB members released from prison after 4 years in detention. APC closes Secretariat Buhari House over murder of kidnapped director. Wiki fires former governor speaking like a child concerning Rivers State emergency rule. Details now. Thank you for staying with us. The news begins with the Nigerian Railway Corporation announcing the suspension of the Warri Itakwe train services for 72 hours. According to a statement today by the NRC management, the suspension will last for the next 72 hours. The statement disclosed that the suspension of the Warri Itakwe train services became necessary as a result of multiple engine failures which affected customers and train schedules along the route. During the period of suspension, the NRC said its technicians would conduct a full audit, resolve all identified issues, and restore hope, safe and reliable services. It added that all passengers with tickets for the affected services are eligible for a full refund or revalidation for future travel based on their preference. The NRC also confirmed that there is no disruption of services on Tuesday, April 9, during a train trip due to engine failure. Now, President Bola Ahmed Tinubu and the Attorney General of the Federation, Prince Lateef Fagbemi, failed to send legal representatives to the Federal High Court in Abuja today for the scheduled hearing of a suit seeking to remove the sole administrator of Rivers State, Vice Admiral Ibok Ete Ekwa Ibas. During the resumed proceedings, neither President Tinubu nor the Attorney General of the Federation was represented, although the Attorneys General of Lagos, Bayelsa, Taraba and Edo states had representatives present. Counsel for the plaintiff, Mr. Chimeze Inuka, informed the court that all defendants except the Attorneys General of Zamfara and Bauchi states have been properly served with the originating process and hearing notices. After agreement amongst the lawyers present, Justice James Omotosho postponed the hearing to June 11, 2025 and ordered fresh hearing notices to be served on all the defendants. The suit was initiated by Abuja-based lawyer John Mary Jidobi. He is seeking a court ruling to declare all actions and decisions made by Vice Admiral Ibas in his capacity as sole administrator of Rivers State as unconstitutional and null. The plaintiff also seeks a perpetual injunction to prevent President Tinubu from interfering with the tenure of elected governors and from appointing any sole administrator in any state of Nigeria. The plaintiff argues that the president has no constitutional authority to remove, suspend or tamper with the tenure of a duly elected governor and deputy governor, and that the appointment of Ibas as sole administrator of Rivers State is unconstitutional. The suit also seeks to set aside the suspension of the governor and deputy governor of Rivers State on March 18, 2025 and the subsequent appointment of Ibas. Jidobi maintains that while President Tinubu has a constitutional power to declare a state of emergency in certain situations, he does not have the authority to suspend elected officials. He also expressed concerns that the president's action could lead to a dangerous precedent that undermines Nigeria's democracy and legal framework. Meanwhile, President Bola Ahmed Tinubu and his team has tendered an apology for the errors in the list of appointments released to counter the narrative about President Bola Tinubu's alleged lopsided appointments. The president's appointments have been a topic of conversation lately as opposition politicians accuse him of favoring his tribesmen and women over Nigerians from other ethnic groups. Senator Ali Ndume, an APC lawmaker representing Borno South, in a recent interview with a Monitor television program, accused the president of violating the federal character principle in his his appointment. Ndume said he decided to call the president's attention to his lopsided appointments because as a lawmaker, he has the right to criticize the president even though they belong to the same party. Countering the allegation, the presidency released a list of President Tinubu's appointees and their geopolitical zones. The list showed that the president had appointed 29 people from the southwest, his home region, 35 from the northwest, 22 from the south-south, 16 from the southeast, 25 from north-central, and 24 from the northeast. However, the president's critics have pointed out that the list was not comprehensive, as the name of a major appointee from the president's home region was missing. The omission of the president's chief of staff, Femi Gbajabiamila, from the list further strengthened the regional imbalance narrative against President Tinubu's administration, as the list clearly showed that the southeast is highly underrepresented in his government. As a document triggered debate on social media, the special advisor, media and public communication spokesperson to the president, Sunday Dari, has apologized for the errors in the list. Moving on, Senate President Godswill Akpabio has formally petitioned the Inspector General of Police, Kaide Egbetokun, requesting an investigation into an alleged assassination plot against him by Senator Natasha Akpoti-Uduaghan. Now, the petition dated April 3, 2025, comes after Akpoti-Uduaghan's public outburst on April 1, 2025, in which she accused Akpabio of instructing former Kogi State Governor Alhaji Yahaya Bello to assassinate her in Kogi State. She claimed that the plot was designed to make it appear as though her constituents were responsible for her death. In his petition, Akpabio vehemently denied the accusation, calling it a heinous lie and a reckless and deliberate attempt to tarnish his reputation. He demanded the prosecution of Akpoti-Uduaghan for criminal defamation. The Senate president characterized the allegation as politically motivated, accusing Akpoti-Uduaghan of attempting to incite political unrest and damage his public image. He also emphasized that the accusation was made without any supporting evidence. Akpabio further highlighted the harmful impact of the false allegation, noting its widespread coverage across several and various media platforms, which includes radio, television, and also social media. He urged law enforcement to treat the matter with the seriousness it warrants. Akpabio categorically rejected the accusation, calling it a reckless and a deliberate attempt to damage him, endanger his life and security, and incite political unrest. He also expressed concerns over the political motives behind the false claim. According to him, her motive was clear, which was to incite the public, manipulate sentiment, and malign my person and office in the eyes of the Nigerian people and international community. End quote. A federal high court in Abuja has dismissed a 50 billion naira lawsuit brought by the embattled leader of the indigenous people of Biafra, Nnamdi Kanu, against the federal government. VOP News understands that Justice Inyang Ekwo ruled to strike out the case due to insufficient prosecution efforts. During the court proceedings on Thursday, April 10, neither Kanu nor any legal representative for the federal government was present. Justice Ekwo noted that in the previous adjournment, the federal government had been represented, but there was no legal counsel for Kanu. The judge remarked that the case had already been adjourned 3 times due to the absence of representation, leading to dismissing the case. Kanu had filed the lawsuit against the Federal Republic of Nigeria, and the Attorney General of the Federation identified as the first and second defendants in the case. Kanu's allegations against the defendants pertain to violations of his rights, claiming he was unlawfully abducted from Kenya and forcibly returned to Nigeria for trial. He seeks a judicial determination on whether the circumstances of his abduction in Kenya and subsequent extraordinary rendition to Nigeria complies with existing legal standards. Kanu also wants the court to determine whether by the operation of Section 15 of the Extradition Act Cap E25, laws of the Federation of Nigeria 2004, the plaintiff can be competently legally tried for offences stated in counts 1 to 14 of the 15-count amended charge. He said the count and all the offences for which he has surrendered or extraordinarily rendition to Nigeria. In the originating summons, the leader of IPOB is requesting 11 forms of relief, which include an order for his release from the custody of the Department of State Services. Additionally, Nnamdi Kanu seeks an injunction preventing the defendants from proceeding with a prosecution related to a criminal charge, which is currently before a related court overseen by Justice Binta Inyako. Kanu has also requested that the court grants him 100 million naira as compensation for the cost associated with this action. However, in a preliminary objection notice dated June 6, 2022 and filed on June 27, 2022, the federal government and the Attorney General of the Federation have asked the court to dismiss the case, labeling it as an abuse of court process. One of their arguments is that Kanu had previously initiated a similar case in the Federal High Court Umuahia Division. They further contend that both defendants were involved in that earlier suit, which they argue renders the current case an abuse of court process, thus depriving the court of the jurisdiction to hear the matter. Now, 12 members of the indigenous people of Biafra who had been incarcerated since May 24, 2021 have regained their freedom. The individuals were released from prison today, April 10, 2025, following a ruling by the Ebonyi State High Court. This decision represents a significant legal triumph after nearly 4 years of imprisonment. The information was shared by the legal representative for IPOB, Barrister Ifeanyi Ejiofor, in a statement via his Facebook page today. These detainees were part of a larger group of 36 individuals arrested in 2021 and had previously been discharged and acquitted in earlier court decisions. However, they remained in custody dictated by the formal withdrawal of the latest charges against them by the Ebonyi State Director of Public Prosecution, acknowledging prior judicial decisions. Barrister Ejiofor, who described the development as long overdue respect for the rule of law, oversaw the release process and confirmed that prison authorities complied promptly with the court's directive to hand over the detainees to him. Now, the Ruling All Progressives Congress has shut down its National Secretariat, popularly known as Buhari House, following the killing of its Director of Administration, Honorable Abdurrauf Adekunle Adeniji. VOP News understand that the deceased, who was kidnapped weeks ago, was reportedly killed last month. The abductors concealed news of his murder, even while still negotiating for the payment of a 50 million naira ransom. The APC memo titled Secretariat Closure for the Mourning of the Director of Administration advised all the staff to use a period of mourning for sober reflection and prayers for the family and the loved ones. Meanwhile, a senator on the platform of the New Nigeria People's Party representing Kanu Central, Rufai Hanga, has also disclosed how the former governor of Lagos State and now Nigeria's president Bola Tinubu invited him to Lagos to discuss the formation of the APC. According to Hanga, the APC would not have existed without him. Hanga disclosed this in a recent interview while responding to questions about whether there were any conversations within the NNPP about joining the coalition led by opposition leaders. He noted, however, that his leader, referring to Governor of Kanu State, Rabiu Kwankwaso, rather former Governor of Kanu State, Rabiu Kwankwaso, has been a friend of President Tinubu for many years, and that Kwankwaso had been invited to join the government but was at a point ditched. You're currently listening to the World News at 6 right here on Voice of the People, 90.3 FM. We'll take a very short break. When we return, we'll head into a news analysis segment, where I'll be joined via the telephone with Barrister Tunji Abdulhamid. He is a legal practitioner, a political and social affairs commentator. To kindly stay with us. Good evening, Barrister Tunji Abdulhamid. How are you, sir? Can you hear me, sir? How are you?
I can hear you. Thank you.
Good evening, sir. How are you?
I'm fine.
All right, sir. I am so happy that you could actually be part of the evening, the world news this evening. Barrister Tunji Abdulhamid, it's a lot is actually going on in Nigeria's polity. I'm going to start off again with this particular information with Sunday Diary. Now, there are speculations, or rather, there were talks by critics, specifically a major number of Nigerians, alleging that President Bola Ahmed Tinubu's recent appointments have been lopsided, meaning that he was given preference in terms of major appointments at the ministerial level from persons from the Southwest. And this statement actually was made via a monitor television program by Senator Ali Ndumi. He categorically made that statement. And in response to that, Sunday Diary, one of the president's media aides, released a list of appointment. Obviously, that appointment was not updated. And a lot of critics said, really, is this the competency that the president has surrounding him? And because of that, when critics looked at it and saw that indeed it wasn't balanced, that the Southeast highly underrepresented, just having 16 appointments, you also have for the Southwest all about 29, including the president's chief of staff, making it 30, and then from the from the Northwest 22, his home region, from the Southwest his home region 35, from the Northwest 22, and from the Southeast, you have 16, North Central 24, and obviously from the Northeast as well. So there were complaints that this ranking wasn't balanced, and after that, Sunday Diary now released an apology. How do you react to this development?
It's unfortunate that at that level, such mistakes could be happen. It shows that people around the president are not meticulous enough. So, or maybe they are always in the hurry. So react to issues without due diligence. And that's an embarrassment to the president. You must, at that level, you have to scrutinize everything before being reviewed. This is a statement coming from the president, our presidency. And if you are saying such an error in it, or such inaccuracy in it, it shows that it takes doubt in the competency of people around the president. And it makes people feel like no wonder Nigeria is what it is, that we don't have competent people around the president. But anyway, they are probably because they may not even be probably because it's not lying. They there, and when you now put up the position, you now realize that look, I think it's not good enough. So I think in any way, like I said, it speaks volumes regarding the competency of the people and the meticulousness of the people around the president and the embarrassment of the president.
Yes, and now, Barrister Tunji, let's move on to a recent situation. The Attorney General of the Federation and also the president, as well as other representatives that were meant to represent the federal government concerning the sacking of the sole administrator of Rivers. None of the president's entourage were represented in court today. Now, Prince Lateef Fagbemi failed to send a legal representative to the Federal High Court in Abuja today for the scheduled hearing of a suit seeking to remove the sole administrator of Rivers, Vice Admiral Ibok Ete Ekwe Ibas. Now, during the resumed proceedings, neither the president nor the AGF was represented, although the Attorneys General of Lagos, Bayelsa, Taraba, and Edo State had representatives present. Why will the president's team, or specifically the Attorney General of the Federation, not send any representative? Are we saying when it comes to court appearances, some certain persons are excluded? I don't understand if you know where I'm coming from. Why was that due diligence to just obey court process? They got the originating summons, they received it, it was acknowledged. So why snub it?
Esther, when you are served with court protest, it is your choice. Except it's a criminal matter. That's when the accused is under obligation to appear in court. If it is civil matter, you have a choice to come or not to come. If you fail to come and defend it, the case will not stop. They will proceed after a while. They will ask them to start hearing you again, and thereafter they will proceed. So what I'm saying directly is that whether you deliberately or not deliberately to come to court, it does not stop the court from doing its business. And it's normal in practice in our system. If you are served with the process, you can decide to come or not to come. Maybe probably you are still preparing your document, or preparing you are not ready to come, or probably you even receive the paper late. So it's part of your. I won't impute anything to that. There may be a lot of people for me. It's not coming to court does not mean it doesn't. It didn't come to court. It's even good for those who fight the case. That means they are saying it's not defended by the petitioner. That is the meaning. So once the court is satisfied that they've been served and they think, like for instance, the matter came up today, as you said, and they are not in court, the court is order hearing notice. If they have been served, if the court is satisfied that they have been served, they will order hearing notice to inform them that the matter is subject for 2 and 2 days again. If they refuse to come, the court can still give them another opportunity. Or the court may say, okay, now that they're not here and they've not filed anything, let's proceed with the case. So in that regard, the case will be determined as if it was not challenged by anybody. So it's at their own peril. They pay to appear. If they pay to appear, it's at their own peril.
Interesting. Very recently, appointments were made by that sole administrator, appointing local government administrators, choosing some persons to work within the state echelon of the state hierarchy in terms of service. All of this, there are talks that, okay, he doesn't have a constitutional right to do any of that, make appointments, install persons to oversee and all. So if he's making all these appointments now, what happens after the 6 months elapses and Fubara returns? What will happen to those local government representatives that he has appointed?
Yes, sir. He does not even have the power to be on that seat. That is the reality. He is on that seat illegally.
So you mean the president illegally installed him there? Is the president thriving on illegality?
There is nothing in our constitution which says I'll give the president the power to appoint an administrator to govern anything. Section 1, Section 2 of the Constitution states clearly that the Federal Republic of Nigeria cannot be governed, nor shall anyone, individual, group, or person take control of the Federal Government of Nigeria or any part thereof, except as prescribed by the Constitution. What is the petition under the Constitution? The petition under the Constitution is that there must be elected governor in each state. It was the administrator elected. The Section 572 of the Constitution, 1999 as amended, vested the executive power of the state on the governor, not administrator. And the governor by Section 176 of the same constitution is considered as the chief executive officer of the state. So in other words, in everywhere where they talk about who will be in charge of the state, it is the governor they are referring to. There was no mention of an administrator. So in other words, what I'm saying is that the appointment of administrator to head the state or to govern a state is an aberration under our law. It's not known to our law. So what I'm saying directly is that the foundation is not proper. So whatever step that the auditor is taking, it will be amount to illegality. So whether it's appointing or not appointing, or whether it's removing or not removing, it is legal as far as I'm concerned. He has not based under our law. And that's why he has no power to even. That's why people are complaining if he takes any step. There will be complaints because he's not governed by any law. Even the president, even the military regime, they have decree and they rely on that decree to rule. And this administrator in liberty has nothing to follow. The only thing he will follow is directly from the president.
So you're saying now that these appointments he has made that you consider to be unconstitutional, besides the fact that according to you, he's not even meant to be there constitutionally, and all the appointments he's been making lately is unconstitutional. So if he is not paying any attention to what anybody is saying, which is in contradiction to what he is doing, then that means he has the direct authority from the presidency to do what he is doing, right?
Of course, who gave him the power? That is the president. That's why I said that the only constitution he's following is the president. The president is his constitution. So he has no respect for. He has no mandate to deliver anything in the state except what the president says. So he has no attempt to render to anybody in the state because nobody else gave him any mandate to do anything. So it's like I said, all the things that's been done. In fact, regarding emergency rules, regarding suspension of the governor, are not known to our law. They are apart from society legality. And there is no way the administrator will take any steps that will not be considered as abnormal because it's not governed by any law. There is no law that says advisors can be appointed when they say the emergency is declared. The mode of suspending or removing the mode of removing the governor is clearly stated in our constitution. Section 180 of the constitution and section 188 of the constitution provide how a governor can be taken away from his office. If he dies, if he is removed, removal is what they call impeachment. That's section 188 of the if he resigns, if he dies. So those are the circumstances under which he can be removed.
All right, let me ask you this. With these appointments he's been making, Barrister Tunji, right now, you remember that this is just about a month into the state of emergency declared, right? The president had actually said Fubara and the House of Rep members will be suspended for 6 months. Now, the House has come to tell us that they're looking into this and that they have reduced that 6 months to possibly a few months, maybe in a month or so, but they didn't tell us precisely what month it is that the River State state of emergency would actually elapse. You know, they've reduced the sentencing from 6 months to something lesser, but they didn't specifically tell us when. My question is, if this man, this sole administrator, is making appointments in critical places without constitutional authorities or without being recognized via the constitution, what then happens if this suspension elapses? So when the governor comes back, will the sole administrator dissolve all the appointments he has made? Or is this a way through which something has been permanently put there, and maybe when Fubara comes, he has no choice but to work with what the sole administrator has implemented?
How can the governor come back and work with structure put in place by somebody who has no power to put it in place? Even the structure that has been put in place by the people, by the governor elected by the people, has been thrown out by the person who has no power to even be on the seat. So the answer simply is that the governor has a discretion to either continue with it or dismantle it. So it is his choice when he comes back. If he's allowed to come back.
What do you mean if he's allowed to come back?
I will not be surprised if he's extended till the time we'll do another election.
What?
I will not be surprised.
Is that possible?
I will not be. Are you not seeing the handwriting on the wall? The man came from another state to River State within a month, and is able to draw up names of people who occupy positions from River State. How did he get them? You not see handwriting on the wall? So if I will not be surprised. I'm not saying that is the position. I will not be surprised if that emergency is extended. I will not be surprised.
What do you think the PDP governors will do? Specifically, the PDP as a party. They've been so silent.
They've taken the next step. They are already in court. 11 governors of the PDP are already in court. The 5 states and the Supreme Court. They are challenging they are asking the court to interpret the provision of section 1 of section 2, section 5 of section 2, section 4 of section 4, section 179, section 180. They are saying that having regard to this section, can the president suspend any governor in the constitution? Can the president appoint an administrator? Just issue already before the court and the Supreme Court for that matter. But I do not expect that matter will last long. And I expect the Supreme Court to do the right thing. Otherwise, if the Supreme Court may be set, if that position is affirmed by the Supreme Court, dangerous precedent is being set. And on that day, I think I will ask up and say, look, Nigeria, here we are.
Interested. Barrister Tunji, a federal high court sitting in Lokoja has directed that hearing notices be served on 2 petitioners by substituted means in the ongoing case concerning the recall of Senator Natasha Akpoti-Uduaghan. The order issued by Justice Issa Dashen today followed an ex parte motion filed by the plaintiffs through their counsel, right? Now, the plaintiffs include Anebe Jacob Ogrima, John Adebisi, Musa Siyaka Adeza, and Ahmed Usman, including Malik Yahaya. They had initially obtained an ex parte order on March 20, preventing INEC from accepting any recall petition against Senator Akpoti-Uduaghan. But the court had vacated this order on March 24 after INEC filed an application stating that no party or institution could impede its constitutional duties. All right. Now, in the plea right now before the court, counsel to the plaintiffs are actually explaining the difficulties encountered in serving the two petitioners, Habib and Omoli, with the originating summons and hearing notices. So the question is, with the recall proceedings continuing, is there a tendency that while this case is still in court, another recall process could commence and INEC may actually have to work on any recall process or any recall petition being filed at the court to ensure that Natasha Akpoti doesn't return after her 6-month suspension elapses as well at the National Assembly?
Let me say firstly that I do not think that case will continue to be in court again.
Okay.
I think it has been overtaken by events.
Okay.
Because INEC has come up and said that the petition failed, and therefore they won't progress with that petition. So, in my opinion, that particular case, they should do the duty and discontinue the case in court. The fact that the INEC try to say that petition failed, it does not preclude them if they have another reason or the same reason to take steps to recall Natasha. In as much they are able to meet the requirements of the law. So if they are able to meet the requirements of the law, the fact that the one has been decided upon and the thing has been told up does not stop them from bringing another one. If they have the members, if they are able to gather the necessary signatures, and then they find it before. I'm not telling you need to do them from doing that. If they are right, they have the right to perform to them under the Constitution.
Yeah.
And if they are able to meet the requirement, they can be under.
All right, Barrister Tunji Abdulhamid, coming to the case of Nnamdi Kanu, the court has vacated his 50 billion naira suit against the federal government for his extraordinary rendition coming all the way from Kenya, his continuous incarceration within the DSS, and the fact that there should be payment of about 100 million naira for abuses and or whatnot, which he considers a defamation or a limitation of his fundamental human right. Why do you think that's okay? Why was that dismissed against the federal government? I mean, was there no room through which there are a lot of, will I say, repairs that needs to be made coming from the federal government concerning the way through which he was extraordinarily renditioned?
Let me say that I am not seen to be part of that case.
Okay.
I don't have the details of the case, so I will not be in the right position to say what actually happened and why what they did was happened. And that's that. I've not read that report or that particular.
It was actually today. The Federal High Court dismissed the 50 billion lawsuit brought by Nnamdi Kanu against the federal government. And the report is that Justice Inyang Ekwo ruled to strike out the case due to insufficient prosecution efforts. That during the court proceeding today, neither Kanu nor any legal representative for the federal government was present. And Justice Ekwo noted that in the previous adjournment, the federal government had been represented, but there was no legal counsel for Kanu. The judge remarked that the case had already been adjourned 3 times due to the absence of representation, leading to dismissing the case. And if Kanu had filed the lawsuit against the Federal Republic of Nigeria and the Attorney General of the Federation, Kanu's allegations against the defendants pertain to violation of his rights, claiming he was unlawfully abducted from Kenya and forcibly returned to Nigeria for trial. So why wasn't he present in court?
No, for what you have read now, that's what we call lack of judicial prosecution.
Okay, explain please.
If you file a case in court and you fail to appear before the court to prosecute the case, then you have abandoned it. So
Wow.
for what I said, they say about 3 times or 2 times.
Yes, 3 times. It's either he doesn't represent or or the federal government sends no representative.
Then it is presumed that they are not interested in prosecuting the case, and the court cannot continue to wait. That's it. So I think it was dismissed for lack of judicial prosecution.
All right, Barrister Tunji Abdulhamid, thank you so much for giving us your insight and some of the questions posed at you on the World News at 6. I sincerely do appreciate your input.
Thank you for having me.
All right, thank you very much. That was Barrister Tunji Abdulhamid. He is a political, national, and social affairs commentator, also a legal practitioner, right there, giving us his insights and his perspective to the questions thrown at him on some of the stories that we read out on the world news. Now, on to stories outside the shores of Nigeria. Ukrainian President Volodymyr Zelensky accused Russia today of working systematically in China to recruit fighters for its war in Ukraine, days after announcing Ukrainian forces had captured 2 Chinese men fighting for Moscow. China had warned Ukraine today against making irresponsible remarks after Mr. Zelensky said Ukrainian intelligence had revealed at least 155 Chinese citizens were fighting for Russia. He posted footage of an interrogation with one of them, which Reuters could not, however, independently verify. Kremlin spokesperson Dmitry Peskov denied Mr. Zelensky's claim and described Beijing as taking a balanced position. China, which has declared a no-limits partnership with Russia, has tried to position itself as an actor in attempts to negotiate an end to the war. It is not known to have directly aided Russia's 2022 full-scale invasion of Ukraine, but has refrained from criticizing Moscow. And now to wrap up here again are the top stories. You heard that NRC suspends Warri Itakwe train services. Also, in a recent development, President Tinubu AGF Fagbemi Snubs suit seeking to sack Rivers Sole administrator. In a very recent development as well, Godswill Akpabio petitions police over assassination plot, wants Natasha Akpoti prosecuted. In a very recent development, court dismisses Nnamdi Kanu's 50 billion naira suit against federal government. Also, 12 IPOB members released from prison after 4 years in detention. Also, APC closes Secretariat, Buhari House over murder of kidnapped director. Now, also, Wike fires states Rivers emergency rule here. And Federal High Court orders substituted service and recall petition case against Natasha Akpoti. That's a wrap on the World News at 6. My name is Esther Machuku. Good evening and thank you for listening. Up next is the Evening Rush at 7.